So for question 6, we're looking at individual rights that you have within the GDPR, and there are 8 rights when it comes to individuals' personal data. Each one of these is actually shown on the same page here. So the right to be informed, the right of access, right to rectification, i.e. fixing stuff, the right to erasure, the right to restrict processing, the right to data portability, and the right to object. Okay. So the right to be informed is one of the main important requirements. So you have the right to be told about any personal data collected and how that data will be used. This is the reason why we have the cookies message that comes up on websites constantly. The right of access. Individuals must be allowed access to their personal data and can make a request to do so verbally or in writing. You must respond within a month of a request, and you cannot charge a fee for access. You can, however, charge a fee for the admin that it takes to actually give that person that information. So a lot of things, there might be like a token sum, £5 or something like that, to actually get access to your data. A lot of big companies like Facebook actually allow you now to download all the data that they have on you in one single file. If you search downloading all your data on Facebook, it's quite scary sometimes how much information they have on you, and it's worth having a look at. The right to rectification, i.e. fixing stuff. If the personal data is incorrect or incomplete, individuals have the right to have the data changed or updated. Organisations must respond within 1 month of a request, and there are some reasons why a rectification request can be denied. Sometimes it's in the public interest for that information to stay as it is. Twitter, tweets at the moment you can't edit, and you have no right to make a change to those information as you edit it, because it's being then responded to in the way that it's been added to. So if you put a message on there and people reply to it, you can't actually edit that message, because otherwise it might change the meaning of what the people have actually responded with, which could then lead to other forms of criminal case, etc. So although Twitter doesn't hide behind this as their reason, sometimes these are the sorts of reasons why something has to stay incorrect or incomplete, and you might add an extra record into a piece of data to say, please note, although we can't change it here, the actual correct information is this, something along those lines. The right to be forgotten, or the right to erasure. An individual can make a verbal or written request to have their personal data erased. Not all data can be erased, and there are some instances in which an organisation can refuse to erase data. Organisations must respond within 1 month of a request. You have the right to be forgotten on Google. So if you search your name on Google and things about yourself come up that you don't want to come up when people search your name, you can actually write to Google, or you can send a message to Google via their online forms and say, I want these links removed from your database, please, and they will respond to that request. If you search enough on Google and get to more than just the first page, or get to something with very few results, you get to like the end point, which actually says, although there may be some extra results on here, they've been removed by the right to be forgotten, or are too similar. The right to restrict processing. In certain circumstances, it is possible to request that personal data is restricted or suppressed. Restricted data can be stored but not used. Organisations must respond within 1 month of a request. At the moment, there's a lot of things going on with medical information being collaborated together from GP surgeries and put into a centralised database. And you currently have the right to say, I don't want my information added to that database. Therefore, your personal data is being stored by the GP, but is not being used for a specific purpose. So you're restricting what it's actually being used for. Again, there's sometimes when this isn't possible, legal reasons and things like that, where it actually comes down to a judge's decision rather than the decision of the GDPR. The right to data portability, another one the big IT companies can often hide behind. Individuals are allowed to get and reuse their personal data for their own purposes and across different services. This means the data can be copied, moved or transported in a safe and secure way. Only personal data that has been provided by the individual to the controller falls under this right. So you have the right to be able to download all the photos you've stuck up on Facebook, to be able to copy them to Google Photos, for example, or whatever that you might want to do. And it means that if you are a company or building a product like that, you actually have to build these tools in. to allow any personal data to actually be transferred across from one system to another with ease. If it isn't, then it needs to be possible to do that via a manual process. The right to object. It is possible to object to the processing of personal data in some circumstances, and individuals are allowed to stop their data being used for direct marketing. Organisations have to tell individuals about their right to object. A request can be made verbally or in writing, and organisations must respond within 1 month. So again, you have the right to say, I do not want to receive these phone calls, I do not want to receive these text messages, etc. I have the right to unsubscribe, so my personal data is not being used for a certain circumstance. And that's really every email now that is a marketing email should contain a link at the bottom that says this is how you unsubscribe, or a single button to click to unsubscribe. Anyone who doesn't is actually breaking that law, and they are breaking GDPR for that reason. The final law actually applies to computers rather than people generally. Rights in relation to automated decision making and profiling is where your personal data can be used in an algorithm, an automated decision, to make a decision about you, i.e. Whether you're allowed a loan or not. And it can be used for profiling, when Facebook use it to profile which adverts that you're going to see. This comes under this part of the law. So they can include certain restrictions, including the organisation must have a lawful basis for carrying out the decision making or profiling. So in the same way as you're collecting data for particular instances, if you're using it within these sorts of processes, you must again say exactly why you are using it and for what purpose. To use either type of these decision making, the decision must be necessary for the entry into or performance of a contract. This is where advertising comes in. Authorised by union or member state law applicable to the controller, i.e. it's census style information that's actually necessary for the particular place of where you are living, and it must be based on an individual's explicit consent. You must say, yes, I consent to give my information for this purpose. If you choose not to, then it cannot be used in this way. So again, this comes back to what I was just mentioning about the GP surgeries. All GP records are going to be centralised soon, and you can go to your GP surgery and say, I do not want it to be put into the centralised system. In the centralised system, it will be used for doing things like this sort of processing, automatic decision making. It might say, for example, look at how vaccine take-up is around the country, and from that information be able to make a decision based on where vaccines need to be more targeted. But it might be you don't want someone to know what your vaccine information is. And although a lot of this information will be anonymised, it doesn't mean that it necessarily will be. Here is a case study, if you like, is how an organisation would tell their customers about their data. You have to follow related rights. You give a list of exercise right charge, and you can get further information. They could do this, and how it gives an example. So it's just really an example showing you what that can actually look like within an organisation itself. And every organisation should have something along these lines. So now we move on to the role of a data protection officer. This is your answer for question 7, where it actually asks you to describe the role of a data protection officer. So the data protection officer must be independent to avoid conflicts of interest, must report to the highest level of management, i.e. they must be actually on the sort of pretty much the highest level at the company, must be appointed on the basis of their expertise in data protection, so it can't just choose anyone, it has to be someone who actually knows what they're talking about data protection. There may be a staff member, or you can actually apply to have an external service provider, be the data protection officer, and they must be provided with appropriate resources to carry out their tasks and maintain their expert knowledge, i.e. they need continued professional development, or CPD. And their role really is to monitor the GDPR compliance within the organisation, making sure that all the employees as a whole follow that regulation, as well as the organisation itself. They act as the main focal point for any source of information that are necessary within that organisation, and they provide advice on data protection requirements. So an employee should know who their data protection officer is, and they can write to them with any questions that they might have, email them, etc., or phone them, or contact them, talk to them. And they can then talk about GDPR, how it relates to whatever it is they're talking about, and if they don't know the answer, they can find out that information. They provide advice on data protection impact assessments, which is the next thing we're going to talk about, so don't worry about that just at the moment. But they are providing advice to people within the organisation that might need to actually create one of these assessments or utilise one of these assessments. They are also the people responsible generally to provide the training about GDPR within the organisation. So the person who gives the training course to the rest of the staff or as part of the onboard staffing process. In any organisation, it's pretty much impossible to have everything as 100% secure at all times. The only way you could do that is if no users actually used your system, so it was just locked in there for a computer to use and no one else could actually access it. So we need to make sure that we have some sort of process to identify any risks that there are, and we put in place procedures to reduce them as much as possible. So the ICO, the Information Commission's Office, say that you must conduct this when a type of processing is likely to result in a high risk to the rights and freedoms of individuals. Okay, so what does that actually mean? Well, it means if you're storing anything that is very, very personal data, or is using data that could possibly end up being non-anonymised for any reason during the process of what you are actually doing, you need to carry out one of these sort of risk assessments. Okay, so when an assessment is done, it should assess the level of risk that could happen, as well as the level of impact on the affected individuals. If it was, say, credit card details, that would be quite a large impact. If a risk is identified that cannot be reduced, the organisation must inform the ICO, who will provide written advice. So if you can identify those risks and actually say, look, these are the risks within my company, you can write to the ICO so they are aware that those risks exist. That way, if there is a data breach later on, you're actually covering yourself in a lot of different ways. So, what's included in the assessment? Information about the nature, scope, context and purposes of the processing. How necessary the processing is and what compliance measures are in place to keep the data safe. Are you reducing access to only certain members of staff? Are you pre-processing a lot of information before you actually get some data, for example? You must identify and assess the risks to individuals, i.e. the people that the data is actually stored on, and identify measures that can be put in place to reduce those risks. So you must have worked through and decided, how can we actually reduce the risk here? This is the risk, this is how we're going to reduce it. Okay. There are some processes that automatically require you to do a data protection impact assessment. Any new technologies including artificial intelligence. That's important because obviously the data quite often there is anonymised, so it's taking data and it's trying to anonymise it before coming up with an output. But the problem with artificial intelligence is you don't always know exactly how the computer is getting the output based on the given input. So artificial intelligence is a bit of a black box, as we call it. So it's a box we don't really know what's going on inside it. I study artificial intelligence, so I could explain some of it, but even I would struggle. And even my professor of AI at Reading University would also say that he knows very little about how a computer actually makes decisions sometimes than it does. So it is important that you must have assessed what risk there is actually to the input data when you're using an AI type system. Denial of service, i.e. when decisions on an individual's access to a product or service is based on automated decision making. This happens a lot in things like electricity, gas and water companies. If they're going to cut you off automatically if you haven't paid bills, etc., you must actually say what the risks are involved, that if there's a mistake in the system, a glitch in the way that the information is processed about bills, this could actually lead to people being cut off with things that they should have access to automatically, which again could have caused an individual quite a lot of harm. Any large-scale profiling, i.e. when a large number of individuals are profiled at any one time. So if you're collecting a lot of group information together, group data, in order to, again, anonymise it, maybe find trends and analyses, that information must involve a data protection impact assessment. Biometrics, if you use any form of biometrics and process any form of biometrics, or genetic data, unfortunately you must fill out a data protection impact assessment because they are considered some of the most personal data that you can have, and it's used for protecting everything these days, from passwords, computers, data, or it's being used in such a way that it could be very, very personal to yourself. You could have genetic conditions you don't want revealed to an employer, for example. Data matching, if you're combining personal data from multiple sources, so if you've taken multiple routes at obtaining data and you're merging all of those together to match and make patterns and assumptions from things, so trend analysis, i.e. you could take, weather information, and then you could then combine that with personal shopping habits of people and the personal email habits of people. Any form of data matching in that way, you would actually need to undertake some form of impact assessment. Invisible processing. A lot of personal data can actually be inferred from data that has been given from data subject rather than being explicit. For example, if you live in a household of 4 people, it can be implied that that must mean that you live with a family, you live with a partner or children or such like. It might be wrong, it just might be an implication. And that kind of invisible processing must be part of data protection impact assessment in order to be able to show what assumptions and things that you are making when you are taking this data. The assumption that everyone must be of the same family may be wrong if someone is a landlord and has a series of different little self-contained premises that someone's actually staying in, for example. If you're using tracking, i.e. using an individual's geolocation to track them, again, you must have a data protection impact assessment. What happens if that information falls into the wrong hands? What happens with that data when you've finished using it? What are you actually using that information for? And how are you doing your absolute best to make sure that information is anonymised as much as possible? The Apple AirTags system is a really interesting one to look at when you're talking about tracking. It involves basically creating a mesh network of every single Apple device in existence to be able to track using Bluetooth a specific AirTag. And so if you lose it and leave it somewhere, chances are it will be able to be found quite quickly. However, they also have to inbuilt technologies to make sure that if you are if an AirTag is moving along with you, if it seems to be on your person or it seems to be in your car and seems to be travelling to your place of home and work, the computer system will actually alert you that there seems to be an AirTag tracking you, so that someone doesn't use something like that to track your location without your knowledge. There are a lot of rules that you may have seen if you do anything with YouTube about targeting children or other vulnerable individuals, i.e. using personal data for marketing purposes, profiling or decision making. If you specifically target a video to children on YouTube now, you actually have to specifically tell YouTube you are doing that, and it means that they cannot then use automated advertising which is based on any profiling that they've made. All they can use is generic adverts on those videos to actually make money, and this is a specific in a lot of countries, not just the UK, but the reason it's been out to come out is because of GDPR. It's also a reason why you can't use any form of personal data for, say, marketing to children in terms of their what they're actually watching. So children's adverts on TV used to sometimes specifically target people watching that program for some reason. So if you're watching Power Rangers, next advert would be about Power Rangers in the break. And that is actually expressly forbidden now. So if they've got a children's TV programme on, they can have generic TV adverts targeting children within it or during the break of that programme, but they can't actually make it based on that programme, because that is actually profiling, basing it on the fact that, well, we know the sorts of people who watch this programme will be interested in this. That isn't the case when it comes to adult programmes. So any programs that are targeted at an adult audience, for example something like This Morning, all the adverts within that, the breaks of that program will be targeted to people who watch This Morning, again using profiling data. Finally, if there's any risk of physical harm, so if the breach could endanger the physical health or safety of an individual, so if this information gets lost or gets released, it could cause harm. It could be the known allergy that you have or something like that, that someone, if it got breached, they could use that information to target you and harm you. That's the final area that needs to be covered by the data protection impact assessment. Okay. Obviously this page also goes on to what you should do with it if you get a personal data breach. So a data breach is whenever data is lost, accidentally disseminated or accessed illegally, and it's a major issue. A lot of people don't realise just how easy it is to cause a data breach. A local school here in Grantham sent out a spreadsheet on an email for a school trip that said, can you please fill in the spreadsheet whether there's any missing gaps on medical requirements, etc. And it sent it to all the parents and did not just store the data for their particular child or student. It had the entire spreadsheet attached. And this breaches hugely the data protection law, because there may be personal medical conditions that some of those children have that they don't want their classmates or parents of their classmates to actually know about. If you send data to the wrong person, that is the same sort of problem. If information is stolen, a laptop or something like that, there can be some real rules that you need to have in place, part of the data protection impact assessment, where you have to have things password protected if you're doing things with work at home or online. This iPad that I'm currently on is password protected, so that I can make sure that any information that I have on students that might be stored in here can't be accessed by anyone that shouldn't be able to access it. They can be catastrophic to both the individual and the organisation. So there has to be someone, an individual or team, to have a responsibility for managing any breaches and implement strong breach detection, investigation and internal reporting procedures. If you don't know a breach has occurred, you can't do anything to mitigate against it. So you must have things in place that allow you to find out if breaches are occurring. So, organisations have to deal with a personal breach in the following way. You may take steps to contain the breach as quickly as possible, assess the severity of the breach. Personal data breaches resulting in a risk to individuals' rights and freedoms must be reported to the supervisory authority, the ICO, within 72 hours. If there's a high risk on adverse impacts on individuals' rights and freedoms, they must be told of the breach as quickly as possible. Ensure staff know the process to escalate, and keep a record of any personal data breaches, even if they aren't reported. Now, so first of all, how do you know if your data's been breached? You should keep log files for any access to any computers that are used within your organisation. And these should be stored by the computing organisation or the computing part of your organisation, or as someone that outsources. And you should be able to know exactly who's logged in and logged out of every machine and what data they've actually accessed, so that you can make sure that only people who should have access to the data have had access to the data. At any point you can do an audit on any of the audit trails that you have here, and if you find something that could be a possible breach, you must then investigate it. Even if they haven't been reported to you, you need to keep a record of these personal data breaches. So if you've got access to an employee's email and you can see that something's happened that shouldn't have done, you must actually keep a record of these, because they can be important in the future. A lot of big companies try their best to hide when they have a breach. If you've ever had an email from a company saying, hey, we're changing our security systems, so now you've all got to reset your passwords, and you have to click on a link to reset your password, chances are they've had a security breach and all your passwords have actually been discovered or have been lost in some way that someone could possibly identify in the future. So you've got to be very, very careful that you are keeping track of any breaches. Sometimes it can be years before a breach is found, but you must also follow these guidelines as much as possible when a breach happens. Otherwise there is a lot of problems that you can have in terms of fines, etc. The ICO, as I keep saying, isn't there to try and fine you and try and destroy your business. They're there to try and help whenever something actually does go wrong. These are just some examples. You can look through them if you want to, but you don't really need to. They're not part of the question itself. Finally, there's a little activity that you can actually do just to see which ones you require a data protection impact assessment, and you can then check your answer apparently on page 23.